Question 14. Do I have to list my debts to relatives or friends on my bankruptcy petition? Yes. All creditors have to be listed on your petition. The most important question which you will be asked by the trustee goes like this. Did you read the petition before you signed it? Did you list all your assets? Did you list all your debts? Now, the question does not ask, did you list your non-dischargeable debts? And it does not ask, did you list your dischargeable debts? It simply asks, did you list all your debts? And it doesn't matter if the debt is to a friend or a relative. Did you list all of your debts? Your answer has to be yes. And many times someone has to list a dentist or an orthodontist because a debt is owed to the doctor. And many clients want to continue with their dentist, especially the orthodontist. There's never been a problem. You list the doctor's debt on your petition and you tell the doctor's bookkeeper you had to list the doctor, but you're going to continue to pay on your medical bill, which is perfectly correct under the bankruptcy code because you can voluntarily continue to make payments to any creditor once you file a petition, but you can't favor that creditor with payments prior to filing. Once you file a bankruptcy petition, the creditors will want you to reaffirm on their debt. Reaffirmation agreements are complicated, and I have a separate handout on reaffirmations, which is 5 typewritten pages, single-spaced, explaining about reaffirmation agreements. It's simply too complicated a question to answer on this video. I should mention here a question which constantly puzzles consumers and even attorneys who are not familiar with bankruptcy. The question goes, since all my debts are discharged in bankruptcy, why do I have to continue to pay on my car loan or mortgage after I file bankruptcy? Aren't the debts discharged? Yes, your mortgage debt is discharged personally as to you, but the mortgage remains on the property. If the mortgage was removed from the land records, or discharged, then you would own the house outright, and the same with an automobile. And this would lead to the collapse of the banking industry and the economy, because everyone would want to file for bankruptcy and not have to pay on their mortgages and car loans and keep their homes and cars without paying. In bankruptcy, liens pass through bankruptcy, it said, unless specially acted upon while you're in the bankruptcy. Now, second mortgages, which are completely unsecured and have no equity behind them, can be crammed down in a Chapter 13, but not in a Chapter 7. Judgment liens can be removed from your personal residence in a Chapter 7, but a special motion called a 522F motion has to be brought in court in order to remove judgment liens from your home. Another question people always seem to ask me is, if I buy a lottery ticket, does that become part of my bankruptcy? It depends on when you buy it. For example, if you buy the ticket on Tuesday, and on Wednesday we electronically file the papers with the court and get an electronic receipt, and the results of the lottery are announced on Friday, then clearly it is an asset of the bankruptcy estate because you bought it before you filed the petition, and it is considered a potential receivable when you bought it on Tuesday and therefore includable in your bankruptcy estate. However, if you bought the ticket on Thursday and you had filed your petition and had the petition date stamped for Wednesday, then it wouldn't be an asset of your bankruptcy estate. There's actually a case in Massachusetts where this issue really did arise. In all the years I have filed bankruptcy petition, this issue has never arisen. You might be interested to know that several lottery winners have filed for bankruptcy, and I attended an auction of a state lottery ticket which was sold for a cash settlement to an investment company in Australia for approximately $350,000. I was also told by one of the attorneys that the state law on lottery had been amended regarding the transferability of a lottery ticket, which was an important issue in the bankruptcy. Why? Because if it wasn't transferable, then the trustee couldn't sell it. I had one client who did have a limited yearly income from the lottery, but it wasn't anything substantial. This is a rare and actually exotic issue in bankruptcy and is the topic of frequent questioning by my clients because there are reports out that unfortunately many Americans believe that the only way to wealth is through lottery tickets.